SJC-11451, Commonwealth versus Jose Armando Arce.
Good morning, Your Honors. I'm Lois Martin here on behalf of Mr. Arce, and I would just like to incorporate everything that was discussed at this previous case, especially by Attorney Eisenberg. I support everything that she said. To begin with, I would just say that Mr. Arce is not guilty of failing to register. I know you took this case for a different reason, but I would just like to point out he's not guilty of failing to register. And I would ask that you agree that the motion for a finding of not guilty should have been allowed, and I would ask that you vacate his conviction and find him not guilty. I realize you took this case for a different reason, but the facts are clear. He went up to a police officer and said he was registering. The officer acknowledged that he was registering. There was, even though the Commonwealth said inferences could be said to show that he had been staying at his aunt's house, they were not sufficient inferences. Even his statement that he was staying there has all kinds of meanings. He stays there during the day. He could have been staying there. He could have been staying there for 1 or 2 nights. He testified he was staying at a shelter. His aunt was getting his money. This is a man who testified he's cognitively challenged. He had a car accident. He's been in and out of the system, first DCF, then the correctional system, for almost his entire life. He's not a person who fully understands every delicate definition of every word. So that when he said he was staying there, he could have meant anything.
But the judge could interpret it to mean exactly what it said.
Sorry.
I'm sorry, that's my fault. The judge could interpret his statement as meaning exactly what the words say, that he was staying there.
Yes, but even if the court had said that, had interpreted, which I guess she did because she found him guilty, that he could have been staying there one night. There's more to just staying. You had to either be staying, as your honors know, 14 days during the year or 4 days in a month. I mean, there could have been anything. Okay. This is a man who has been in and out of homeless shelters when he's not in the Department of Corrections facilities. So he's not a person who really totally is cognitively able, even when he tries real hard, to understand everything that's happening to him. And so that the fact that he was so diligent and he went right up to the officer. I mean, how many defendants actually go up to a police officer and say, I'm doing what you tell me to do? I mean, this is almost like childlike in some fashion. He was, and even the officer, everybody knew him. Even Kim Hannafin, who testified, who was the person who he registered with all the time, she went through everything. It showed the aunt's address was listed as his mailing address and as his closest relative address. As I believe you said in Rosado, I mean, they knew where to find him. If they really wanted to find him, they knew where to find him. So in that regard, I would just emphasize to you that he is not guilty, and he should have had a not guilty entered on his behalf.
I'm sorry? What meaning do we give to this definition of a secondary address, where you must routinely reside for a period of 4 or more consecutive or non-consecutive days in any month, or for a period of 14 or more days in aggregate? The term reside generally speaks of residence, but this is something less than a domicile. Does reside mean basically you sleep there? I mean, how should we interpret reside?
Well, I think that my mother would think reside is sleeping there, but, I think in this day and age, people work nights. I mean, what?
Well, you
and
still
they
sleep,
a
you
few
may
hours
not-
during the day. There's not a traditional lifestyle anymore. And just in my lifetime, I've seen the evolution of things so that I'm not so sure that it means actually living there. I know someone told me that they live someplace, but they're not really from that place. I mean, it's very sort of ethereal in a way of what it doesn't mean. And it really goes back to the fact that sex offenders are being treated in such a fashion that everyone else in society thinks that they're so awful, they're so the dregs of our society, that we should nitpick at every little thing to punish them in some fashion and keep them away. Society is treating them so differently, and this lifetime community parole is a perfect example. They're not given an opportunity to rehabilitate themselves. They're so busy having to put in their daily logs every minute detail they do. They are under what they call, the parole board calls it intense parole. It's listed in Ms. Eisenberg's brief, the document RA 23-25. It lists every minute detail that you could possibly. I think even non-sex offenders would have a lot of trouble following it. It is so difficult. Just if they get involved, let's say they're trying to rehabilitate themselves. I represent a man whose case has stayed right now in the appeals court waiting for this case. He was 11 and 13 when he committed his sex offenses. He's 33 now. He missed a date, so now he's on lifetime community parole. I mean, this is just beyond the pale. If you are at the point where you cannot do anything that you do to try and change your life, to rehabilitate yourself, you are slapped down on. It's like a black hole. It's very unfair. The other point I would just say is that this was a defective complaint for Mr. Arce. It did not list the level that he was at or the underlying criminal charge, the sex offense that he was at. And under Pagan and Gately, it should have. His lawyer, unfortunately, at trial did not object to the lifetime being. This was a bench trial, as your honors all know. And when he was sentenced, she did not object. However, there doesn't look as if there was any from the record, any indication that this was ever brought up in advance, that she was ever notified. She never had an opportunity to argue the case, the issue of lifetime community parole. And so for that reason also, I would suggest that this case, he should have been found, if you don't find him not guilty, that the lifetime community parole should be vacated.
Could I just, as a point of confirmation here, you're saying that it's not on the complaint what the actual statutory offense was? It did state the statutory offense, didn't it?
No, I don't believe it did, your honors.
Well, I'll recheck
You're
the,
referring to the underlying statutory offense, not the crime charged here,
It
correct?
says level 2 or level 3. It doesn't.
but it doesn't matter whether it's level 2 or level 3 for the purposes of this. You're not arguing that this was given as a mandatory CPSL, right? It was, you don't make the argument, so I'm assuming it was as a discretionary imposition.
I'm sorry.
It was given as a discretionary imposition, CPSL.
I think so. I don't
Okay.
know what was in the judge's mind, but she did say that. And Mr. Arce is a level 3, so in his case, it would be mandatory
Right.
if this wasn't a defective complaint by not alleging that what level he was at or what crime sex offense he had committed. Under the lifetime community parole, it's imposed supposedly to prevent classified sex offenders from reoffending, but it's being imposed, as was shown in the earlier argument, for all kinds of things that are not, seem totally unfair in our kind of system of justice. Mr. Arce he has been found in violation of lifetime community parole. The first time he was not able to, he was serving a sentence for a different crime, and he was unable to be released because he did not have a home plan. As I said before, he's a person who is in and out of institutions or homeless most of his life. He did not have a home plan, so parole would not release him. So he was serving additional time. He was held for months because of that. Someone like him, I'm sure, is not that unusual. There's a lot of homeless people that are sucked into this whole system, and what do they do? I mean, really and truly, it just seems like we're not, any efforts at rehabilitation seem to be sucked out of it by the intensive parole supervision issues. As I said, Mr. Arce is cognitively impaired. I believe he's actually an undiagnosed mental health person. He doesn't understand what's appropriate and what's not appropriate.
Can
And I'm sorry?
Can I go back? I was just trying to pull out the criminal complaint. I don't understand your argument. It says on July 20th, 2010, being a sex offender who had been classified as level 2 or level 3 and required to register knowingly failed to register. What's wrong with this complaint?
The complaint, Your Honor, I'm sorry, I just...
What's wrong with this complaint? You said from the beginning this is a defective complaint. I'm just trying, I've got it in front of me. I can't figure out.
The complaint, it says, as defined by failure to register, but it doesn't define the sex offense that he has been charged with.
Does it have to? He's
Yes,
charged as a
according to
level 2
Pagan and
or a level...
Kately, you have, this court has stated that it should say a vagueness. It shouldn't just say level 2 or level 3. It should specify his level or the crime.
Well, it's probably sufficient under Fernandez, but I think it's a fairly minor point. We can look to the...
I appreciate it. I'm sorry. I just
I'm
wanted to
sorry,
check
no.
that.
Mr. Arce's sex offenses are significant, but far from the worst. They're totally inappropriate, but not actions that I would suggest should be punished with life in prison, which is
Are
probably
you
what's
arguing
going to
that they're
happen.
completely unrelated to protecting society? Is that what you're saying? These particular offenses, not the statute as a whole, but these particular violations where, because he could be found, the concern that he might just be roaming around looking for other opportunities is absent. Is that something that I can read into your
I'm not saying that. I actually agree with Ms. Eisenberg about probation. Mr. Arce committed all of his crimes, and he has a lengthy record within the jurisdiction of the Lowell District Court, except for one incident of resisting arrest in Concord District Court. I'm not sure about that. But I would just say they know him at Lowell. They understand him. They know the system. They know where he comes from, and they understand, I would suggest probation understands how to handle him. Whereas, and a court has discretion, something that a parole department doesn't have. Parole has, probation has discretion, and a judge, these come into the district courts. The district courts are community courts. The judges, generally speaking, know most of the people, the repeaters, the people who show up here regularly. And I would suggest, unfortunately, Mr. Arce is one of those regulars, that they would know they would be able to use their discretion to formulate some way that he would possibly even maybe get into a system where he is not always getting in trouble. They would develop a relationship, the probation officer and the judges. I've been in front of many district courts judges, and they really do understand their population and have it's a little more personal. Parole is generally for people who are out of the superior court. Very few people out of district court are involved with parole. It's a whole different system. And actually, at these parole violation hearings, one of my clients whose case is on stay, he was taken in because he was and that's the other problem. There's so few places for these people to live. He was living in a homeless shelter. There's very few beds at homeless shelters for sex offenders, and many of these shelters are not the best places. The one he was at, his parole officer acknowledged, was very heavily problems with drugs. He was picked up, they claimed he had a bad urine, so he was taken into custody. There was no ability for him to at all prove anything different, because instantly he was taken into custody. He had to ask for a hearing. It's not an automatic. You don't automatically get a hearing. And because I represented him on the appeal, I went to that hearing. But generally speaking, he would not have anybody speaking for him, and he got a 6-month sentence based on very little evidence on one bad urine strain, which I disputed may not have even been an accurate one, but we had no evidence because it had already been destroyed. In a probation setting, there, as this court knows, there are very rigid probation violation rules that must be followed before someone is sent away for prison. As Ms. Eisenberg said, this can go on and on and on for life. And unfortunately, because of Mr. Arce's own problems, I suspect this will happen to him for life. He doesn't quite get it. One time he violated because he couldn't seem to get his GPS properly charged at the right time, so they kept getting notice. I guess there's some sort of electronic thing that tells him when it's down, it's going down, and he wasn't charging it at the right time. Then he said he also went out for a cigarette, which is after curfew. You're not supposed to do that. I mean, some of this stuff, to end up going to jail for a year, I think seems to be honestly beyond extreme. It would be better, it seems to me, instead of the legislature, I think, was responding, unfortunately, to the public's to pressure about the people being sex offenders running loose on the streets. But if you look at recidivism rates, failing to register has not been shown to show any difference, whether you're registering or not. I would just conclude by saying that, as I said, I would ask you to vacate this conviction and find my client not guilty of this charge.
Thank you.
Thank you, counsel.
Thank you.
May it please the court, Laura Kirschenbaum, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. I'd like to start just by commenting on the defendant's parole record. He was not returned to jail because of simply not having his GPS functioning. He did receive several warnings before he was ever found in violation. So this isn't a case where a simple technical violation results in imposition of a further sentence. And I'd like to go back to the defendant's argument about the defective complaint. As your honors noted, the complaint does state the predicate condition that subjected him to the enhanced penalty. That's all that's required under Fernandez. It's the same as saying you're being charged with a subsequent offense, drug offense, and by seeing that you had this prior drug offense, you know it's a like offense, you know what's subjecting you to this enhanced penalty. And it's the same case here where the defendant knows that he's being charged as a level 2 or level 3 sex offender, and the complaint says he is subject to the enhanced penalty of community parole. And I'd just like to clarify that it was imposed in a discretionary manner, as is required under Williamson.
So under secondary address, when does one reside someplace?
Your Honor, a secondary address would be routinely lives, abodes, or resides.
What does that mean? I mean, if I go to a person's home every day for 3 hours, do I reside there, even if I sleep at a homeless shelter?
Your Honor, the purpose of the secondary address requirement is to ensure that sex offenders aren't located in places where they shouldn't be, like near schools or exclusion zones. And just because they're not registering those addresses as permanent addresses, the SORB needs to be aware of where they might be located on a regular basis.
Is there any claim here that his aunt's address was one of those locations where he shouldn't be? I didn't see that in the record.
He had only listed his aunt's address as a mailing address.
Right, but you're claiming that it was really not. So is it, for the purposes of, you're saying the underlying purposes of the statute, figuring out if he's near a park, right, or some other school? What is it?
There's no information in the record as to whether it's one of those places that he shouldn't be. But my point was that the underlying purpose of the statute is to ensure that he wouldn't be in one of those locations. And without registering that address, there's no way to ensure that this defendant or any other defendant.
How does he know to register it if he doesn't think he's living there? Because how do you know? I'm not even sure you can tell us if he's really residing there. I'm not sure if I understand, just to follow up the question and emphasize. What if he was there napping every afternoon because he can't really sleep in a homeless shelter?
Your Honor, he would be residing there for the purposes of the statute. It would be a secondary address.
Just had dinner there.
If he just had dinner there once, then it wouldn't qualify as a secondary address.
Once a day? Once a week? What? You mean
He's got
residing
it as a mailing. Was he convicted of not having a secondary address and not notifying of change of address, or both?
He was,
Both?
the Commonwealth proceeded on both providing false information and failure to give notice 10 days in advance of a change of address.
So what was the false information?
That he registered on July 12th, and 8 days, he registered as homeless, and 8 days later was found at his aunt's house that he had been staying there. And so the Commonwealth's theory is that he was not, in fact, homeless when he registered as homeless.
But I mean, this goes, you're sort of missing the point here. It's not secondary hangout place, it's secondary residence. What is the definition that's going to be not constitutionally vague of when one resides at a place as opposed to hangs out at a place? I mean, when you're homeless, you may be hanging out on the street, probably are. And you may be hanging out in a place where you perhaps shouldn't be, but you're not in violation of the law. So when does a hangout become a residence?
Your Honor, I would suggest that it becomes a residence when it's a place that you routinely do your living. You're maybe not just visiting somebody, but you're actually doing work there, or hanging out by yourself there, or doing more than just visiting somebody else who resides there. And in this case, the defendant said he was staying there, so there's no question as to whether he was just hanging out there. He was staying there. He admitted he was staying there. So in this case, he should have registered that address.
So secondary, that's a separate requirement, right? You got to say where you reside, and you got to say what your secondary residence is if you have one, correct?
Yes.
But he was charged not with the secondary residence in this case, was he?
He was charged as providing false information, and it didn't explicitly state that the false information was failing to include the secondary address. He should have included it either as a permanent address or as a secondary address, and he didn't do either.
That's the basis for the false information?
Yes, Your Honor.
The only evidence you had was that he acknowledged staying with his aunt?
Your Honor, he acknowledged staying at the aunt's residence while he was looking for an apartment. He said, in the past tense, I've been staying here until I found a new place, and I was going to register the new place when I found it, which indicates...
Any indication of time, duration?
Yes, Your Honor. The landlord had seen him there almost every day throughout the
Him
summer.
there for all day, at night? Anything about the duration of his stay? Either on a daily basis or over a period of time? Any evidence as to that?
Your Honor, viewed in the light most favorable to
No,
the
I just want to
Commonwealth.
know what the evidence was.
The evidence was that he admitted he was staying there until he found a new apartment, and that the landlord had seen him there almost every day throughout the summer.
But nothing more than that? Nothing in terms of how long for what periods of time the landlord saw him there, when the landlord saw him there?
Well,
Nothing about that?
The landlord said it was almost every day throughout
Almost
the
every day,
But not when in the day.
when in the day?
summer. He didn't specify that, no.
Right, so there was nothing more specific than those generalities.
That's the case, Your Honor.
And the landlord, I thought, told him to leave each time.
The
he saw him.
landlord did tell him to leave every time and said, don't come back, and had to repeatedly tell him that. Yes, Your Honor. But this case is not like bowling, where there was insufficient evidence, because there was no specific address that he was supposedly supposed to register. Here we have a specific address that all he had to do was give notice that he was staying there. And if he got a new apartment, he would have to register that new address. But he didn't do any of that.
Well, he did continuously register in a homeless shelter, and he identified
45
precisely the
days.
homeless shelter that he was in.
He did not register a homeless shelter. He only registered as homeless in Lowell.
Every
I
45 days.
thought he gave a particular, I don't remember the name, Middlesex shelter?
When he testified, he said he had been staying at Middlesex Shelter for close to a month, but he never registered that address, ever. So he, in fact, admitted to a separate violation while he was on the stand, but that's not
Can't
part
be
of the
homeless and
Commonwealth
living at a
case.
shelter?
I beg your
You
pardon?
can't be homeless and staying at a shelter?
You could register as homeless with a particular shelter as your address.
So you have to give a particular shelter even though you're not necessarily going to stay there for long periods of time?
I don't think that it is required that you state a homeless shelter. He wasn't found in violation because he said homeless without listing a shelter. But if he were staying at a shelter for close to a month, he would be required to register that as a permanent or temporary address.
Isn't there an enhanced requirement for registering if you register as homeless?
Isn't there
You have to come in more often if you are registering.
30 days now.
Yes,
Every
Your Honor.
45 days, right?
At the time, it was 45, now it is 30 days, yes.
So
And-
it's more, and that's more than any other kind of registration requirement.
Yes, Your Honor,
And
because
he's doing that.
he was registering every 45 days, yes, but he also had this additional requirement, which he had ample knowledge of, and he signed forms saying he was aware of it, that he had to
signed a form
register.
saying he knew, and then he said, I'm doing it right, I'm doing it every 45 days, and he also listed as his mailing address the very address where they found him,
Yes, and
where he picks up his mail for his checks.
he said that he has his mail sent there, which further indicates that he was staying there.
And what is a mailing address if you can't go pick your mail up?
He could have had a P.O. box. He didn't have to.
If somebody has a mailing address that's a person's house, that is automatically violation because God knows you must be living there if you have it as your mailing address?
Your Honor, I would just say that it corroborates the fact that he was staying there. I'm not saying that that's sufficient in and of itself to show that he was in violation.
It corroborates at least that he has a mailing address like he says he did.
Yes, Your Honor. But in this case, he admitted that he was staying there, and taking all reasonable inferences in the light most favorable to the Commonwealth, he was staying there long enough that he should have registered this address as a temporary address.
Now, that's another thing which I find perplexing. You have to give 10 days' notice even of a secondary address. Secondary address becomes a secondary address only after you've stayed there 4 days in a row, or 4 days in a period of time. So
Here-
how do you give 10 days' notice of something that doesn't occur until you stay there for a fourth day?
Your Honor, the way the obligation reads on all the forms that Mr. Arce signed, it's that you have to give notice, 10 days advance notice when possible. And if the case arose where he found a place to live on short notice, he would not be in violation because it wouldn't have been possible for him to register that address. And that was the case in, I believe it was Rosado, but that's not the case here. Here, there was nothing stopping him from registering his aunt's address. He knew where he was going to be, and he could have registered it, and he didn't. For whatever reason, he did not register this address where he was staying.
What was his sentence for this?
He received 1 year in the House of Corrections plus community parole supervision for life. And going to the community parole supervision for life arguments that the defendant raised, there's no separation of powers issue here, nor is this, as she suggested, cruel and unusual punishment.
What was the underlying, how long had he been in jail before?
For this offense?
Yeah, before the year.
He received a year in the House of Corrections, but he was also serving another sentence, so he was released from one sentence into another. And the reason he was held at the end of his sentence, pursuant to CPSL, he was detained for 15 days because he was not cooperating as far as establishing a home plan. It wasn't that there wasn't any place that would take him. Part of his obligation was to assist the transitional people with establishing a home plan, and he was not cooperating.
What does that mean?
He was supposed to assist them with developing a home plan for when he left jail.
How do you do that from jail if you haven't had a home? I'm sorry.
By
I'm not
suggesting-
trying to give you a hard time. I'm just really.
By suggesting addresses that he could stay at.
Is there anybody at the jail that helps them locate
Yes,
addresses?
yeah, he had dedicated officials trying to help him find a place to go, and they eventually found him a place, I believe at a shelter, so that he could be released, but they had to do all the legwork without any assistance from him.
Right.
And
So
going,
you said there's just no separation of powers problem, but isn't this legislature which has essentially delegated the adjudication of future offenses for the rest of this person's life to some executive agency?
Your Honor, Sheehan, I believe, settles this issue, and if Your Honors are inclined to take a second look.
1926 case. Go
A
ahead.
1926 case that has not been overturned and is
About
still
that,
good
which
law.
really has to do with where you serve your sentence, as I understand it, correct?
With where you serve your sentence as far as,
Not when, how long, whether you've adjudicating an offense. It's where you serve your sentence.
well, I mean, that's the case in Sheehan. It's that it's the industrial school versus the reformatory. And here, it's whether you get to be out in the community or if you have to go back to jail because you couldn't comply with your parole conditions. But that's the case with traditional parole. Traditional parole, you're released into the community.
You get a sentence.
get a
And,
sentence.
and the parole board has the authority to release you on conditions, and they can revoke that and send you back to serve your sentence, which has been imposed by a court.
Right, and the same is true here. You receive a sentence of community parole for life, and all of the
Which is what? An infinite, potentially infinite number of days in jail.
only if you choose to keep violating.
And who decides whether you have committed these new offenses and violate? Who sets the conditions for your release?
The parole board sets the conditions for your continued release within the community, which is no different than traditional parole. And it's part of their expertise in community supervision. That's why the legislator has crafted this statute to let these offenders out into the community while keeping them supervised so that the community
So
is
these are
safe.
not new sentences. When you're sentenced to a year, one day, and maybe you get out and you're sentenced to 2 years. These are not new sentences.
Absolutely not, Your Honor. And the parole board regulations explicitly state the legislator has not crafted these to be new sentences. Thus, the traditional parole eligibility standards
So these are
don't
suspended.
apply.
These are suspended sentences. Is that what
Essentially,
you're
yes, Your Honor.
Okay,
But it's all,
suspended sentences that are imposed by not a judicial branch, but by the executive branch.
the suspended sentences are imposed by the judge at the original sentencing. The parole board has no
Excuse me, they're revoked by an executive branch agency, not a judicial branch agency.
absolutely, but that's how
Without the
parole
right to
works.
counsel, without the right to appeal for the rest of your life.
It's the same as any parole violation. If you receive a
That's
life
the
sentence,
same as any parole
Oh,
violation?
because the sentence, when you finish your sentence that the court has set, you are out.
You haven't-
cannot the parole board can't keep you any longer.
Your Honor, in this case, you haven't finished your sentence. You're still serving your CPSL sentence and everything that goes with it that was imposed by the judge. You're not done just because you finish your committed time. The legislator has crafted this enhanced penalty that serves a very particular purpose, and they are presumed to be valid in their decision that this is the way to deal with these sex offenders who continue to violate their registration requirements.
Well, then it is exactly, it seems to me, theoretically, you have to look at a CPSL sentence as a lifetime sentence of incarceration with brief periods of suspension. And that, for this crime, has got to violate Article 26, I would suggest.
Your Honor, it's a life sentence of supervision, and it's only incarceration if you fail to comply with your conditions. And I just add that it's not necessarily for your natural life. After 15 years, if you don't commit a sex offense, if you don't commit a kidnapping, and you are not deemed to be, you show by clear and convincing evidence that you are not a risk to the community,
Who
you
gets
can
to
be
decide
released.
that? Who decides that?
The parole board decides that.
That paragon of releasing everybody, is that?
Well, the parole board makes these decisions routinely with respect to parole. And I distinguish it from the case where you receive a life sentence where if you're released on parole and you violate, you could go back to jail for the rest of your life. But that's not the case here. They have to let you out to give you another chance to integrate back into the community, but to do it under supervision.
Counsel, you'll have to leave it there.
Thank you, Your Honors.